Vivek joins Trump as an Amicus Brief filer, saying that Donald Trump should be on the ballot in Colorado in 2024. Some other GOP candidates like Ron and Nikki have said that they don't really care if the Democrats lop off the Republican lead and just install them, because that's the only way they're going to win. And so Vivek came out and submitted a nice amicus brief to the United States Supreme Court. We're liking that. We're going to read through it and see what is inside. Pelosi had a weird statement saying that it's impossible for Trump to be president again. It's like, what do you mean? Why is that? We're going to hear from Alina. She was explaining that this is all rigged, including the New York civil fraud case, since Tishy Latish met with the White House. Kevin O'Leary is supporting this claim, and Vivek is going to explain to us what really is next, what this is all about. Because the Supreme Court, even though it kind of feels like it's a 6-3 court, and what if they come back and they get a little clever with this and something happens? What happens if Trump is not on the ballot? Guess what happens? GOP says, oh, we can't nominate somebody who can't even be on the ballot. Well, what if the Supreme Court comes back and says states' rights or something? And then they say, well, you guys get to decide on your own. They decided, so deal with it, voters. If you don't like it, vote out the secretary. If you don't like it, deal with your judiciary, right? Deal with the states. That could be a big problem, because then the Republican Party says, well, that's our excuse. Boom, Trump's got to go. We can't even have a candidate who's not even on the ballot in a couple states here. And it won't just be Colorado and Maine, all right? There'll be dominoes all over the place. Arizona will probably go. Okay, we'll have some psychos here who, just decide, let's file a lawsuit and do this and all the things. Arizona's a swing state. So they'll say, well, Trump can't even be on there in Arizona. So we got to go with Nikki Haley and Ron. You can see where this is going already. So Vivek is not, fortunately, playing that game, and he's speaking out about it. And so we'll go through this and see what he has to say. But here is the actual filing. In the Supreme Court of these United States, you see the cases Donald Trump versus the Anderson litigants. And this is the brief of Vivek Ramaswamy. Shout out in support of Donald Trump, the petitioner. This is the case of Colorado ballot removal. We know the Colorado Supreme Court, 4 Democrats, already removed Trump. He's still technically printed on the ballot at this moment, but if the Supreme Court finds that they have the right to do that, all of the people who voted for Trump during the primary, when that comes up, literally their votes will be just disenfranchised, thrown in the dumpster. So Vivek is saying this is totally inappropriate. Thankfully, one candidate, at least, is speaking out against the Democrats trying to pick the Republican candidate, which is what this is, and then delete him from the entire election, ultimately. So here is the summary from Vivek. He says, all right, look, Vivek is a Republican candidate for president running against Trump. And as such, Vivek has a unique perspective as a competitor in the Republican presidential primary race. Vivek has satisfied all the constitutional qualifications and also qualified for the Colorado ballot. He's got a profound interest in preserving the right of every voter to cast a ballot for the candidate that best suits his or her preferences, even if that candidate is someone other than Vivek, which is a nice, refreshing thing to hear. Oh my goodness. We hear from Ron DeSantis, Ron's argument is, well, the Democrats are going to take him out, so vote for me. What? So you're just going to let that go and just let them pick who's next? So here's the summary of the argument. They say from Vivek, the conclusion is inescapable. President Trump's political opponents have sought to disqualify him from the ballot in multiple states because they fear they cannot beat him in a free and fair election. Boom. Now, needless to say, the distress of competing against a formidable opponent called Trump cannot justify disqualification under the 14th Amendment. And the consequences of affirming the Colorado Supreme Court decision to remove Trump, if you do that, Supreme Court, it will extend far beyond the dispute over President Trump's eligibility. Specifically, this court's blessing of Colorado, of their interpretation, it will warp incentives for state decision makers and for voters. For secretaries of state and for state Supreme Court justices, the path to national notoriety will be illuminated. All these judges will be jumping all over themselves, and secretaries of state will be chomping at the bit. He says, to enhance your credibility among co-partisans, all you got to do, simply concoct a reason to declare a disfavored presidential candidate of the opposing party ineligible to run for office. You just pull a secretary of state in Maine. Say, wait, I've decided that there was an insurrection here because I read Colorado and I watched the news and MSNBC and Liz Cheney. For voters, the message will also be clear. Scour the records of disfavored candidates for speeches containing martial rhetoric and even policies that had unintended consequences, and then boom, file a removal petition under Section 3. And because it's just partisan hacks that can just decide this in their own state courts, it'll get done. But even if the courts find these consequences unconvincing, you don't care about wrecking the fabric of the country. And ultimately, I think that if the states can start disqualifying Trump, that's basically the end of it. And you can look back to the election of 1860 60 if you want to see how that went. There are strong textual and structural reasons for rejecting the Colorado Supreme Court's reading because it's idiotic. Most obviously, the phrase officer of the United States, officer, in the context of Section 3 was never understood to include the president, obviously. And the constitutional evidence, combined with the disruptive effects of the disqualification, should lead this Supreme Court to reverse the decision below. Now, here's the argument. They say there is an obvious reason from Vivek, who's writing this, who's running against Trump, by the way. There's an obvious reason why President Trump is the only presidential candidate in American history to face a challenge to his qualification. Democrats fear the potential consequences of Trump's election more than any party has ever feared the victory of an opposing candidate. That is true. This is the break glass in case of emergency section that we've been talking about. They're wrecking everything. They don't care. They'll throw him off ballots like in other countries. If somebody else in another country like Putin throws his opponents off the ballots, they say, I can't believe this. What a dictator over there. And then Joe Biden's like, sorry, you're gone. They endorse it, right? This is the Democratic Party working this. And we've had a lot of other presidents, and we've had a lot of other oppositional parties, and we've had a lot of other people who've had official acts that are bordering on the outer perimeter. You even think that from Trump, which I don't. Giving a speech and investigating a rigged election is within the outer perimeter, obviously. That's the executive branch, is to make sure that the executive functions, right? So that is his sworn responsibility to do that. Now, other presidents have done other things that have been much more criminal and insurrectionary over the last 234 years, but nothing like this has happened before. Why? Because of Trump. There's something about him that they just can't stand. Now, histrionic screeds warning of potential Trumpian dictatorship, they have proliferated in the pages of mainstream publications. That's all they talk about on Joe Scarborough's show. Liz Cheney every day. America's over. And thanks to a deluge of worsening polls, Democrats now lack confidence that they can even beat Trump in a free and fair election. And so now they've resorted to grasping for any tool that might allow them to avoid humiliation by being defeated at the hands of Trump. Now, because the court has never pronounced upon Section 3's meaning, Trump's opponents have sensed an opportunity. Mr. Ramaswamy suggests that this court should refrain from opening the Pandora's box. Indeed, America's faith in the electoral process depends on this court's prudence. Constitutional interpretation isn't supposed to be the art of methodically ignoring what everyone knows to be true. When evaluating this case, the court should first consider the consequences of affirming the decision below. Now, they say here, Your Honor, when there's judicial silence, Trump's political opponents have sensed an opportunity and they've seized upon it, saying although neither the 14th Amendment, the drafters of it, nor this court, the Supreme Court, have addressed whether Section 3 even applies to the presidency, we have these individual private plaintiffs in multiple states. They've already weaponized this. They're already attempting to force Trump off the ballot. Now, the reason for these efforts is obvious. Given Biden's historically low popularity and Trump's consistently strong polling as a candidate, Trump's opponents, they lack confidence in their ability to win. Now, these disqualification efforts are not based on any textualist reading of Section 3. I mean, in other words, you can't extract it from the language. But even if they were, disqualifying the candidate who is now leading in both the primary and the general election polls would be tremendously disruptive, obliterating public confidence in our system. Now, one need not admire President Trump to perceive this matter objectively. Even Professor Lawrence Lessig has written that, in his opinion, the re-election of Trump would be the worst political decision of the nation since the Civil War, because they said the insurrection was the worst attack on America since the Civil War, when they forgot about, 9/11, Pearl Harbor, and the BLM Summer of Love. But okay. Now, he has explained at length why the historical record has convinced him, even this guy, who says he hates Trump. Trump's going to tear this country apart. Remember, they said that about Lincoln, too. Like, literally, we're having 1860 flashbacks. Wild. Yet he has explained at length why the historical record has convinced him that Section 3 doesn't apply. So even Lessig, who is a massive anti-Trumper, is like, he notes, one does not need to like Trump in order to see that the law does not preclude him from being a candidate. Womp, 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 womp. Lessig wrote that over at his Medium page. He wrote that in 2023, last year, December. Obviously. Now, but judging from the available evidence, one apparently does need to dislike Trump to conclude otherwise. They say Mr. Ramaswamy, who's the author of this amicus, has advanced himself as a candidate for the Republican presidential nomination because Vivek believes in the strength and ideas and in his ability to communicate the virtue of his platform to the voters. Now, arguably, the inclusion of a strong competitor on the state primary ballots will make it actually harder for Mr. Ramaswamy to win, but he still opposes these partisan efforts to disqualify disqualify Trump because of the effect that it will have on the voters who they are both trying to court. Vigorous political competition ultimately benefits voters more than the candidates permitted to compete for their support. The First Amendment was discussed in this case from 1971 that the Supreme Court wrote in this case called Cohen versus California. Not that Cohen, probably. It says the First Amendment is designed and intended to remove governmental restraints from the arena of public discussion, putting the decision as to what views shall be voiced largely into the hands of each of us in the hope that to use such freedom will ultimately produce more capable citizenry and a more perfect polity in the belief that no other approach would comport with the premise of individual dignity and choice upon which our political system rests. Now, those who seek to disqualify Trump and other candidates from even appearing on the ballot, they fundamentally distrust the American people. Such a good point. It's insulting to you. Okay, if you want to go vote for somebody, that's called democracy. Okay, you get to go vote. You participate. They're the ones who lecture us all the time about the people getting a say. Well, can we just go vote? Again, if we think he's an insurrectionist, we'll vote for someone else, man. But we're too stupid. We don't know better. So they got to censor us, silence our misinformation, and then literally remove the choice that we have as Americans to go cast our vote for the most qualified candidate. They just say, sorry, we're making up something and he cannot be allowed. Now they continue. They say they fear that the voters, if we could evaluate a full range of options, the voters may make the wrong choice because the political elites say so. And so the political elites seek to deprive the voters of the choice entirely. Too stupid. Now there's a better way, and it's the route that Ramaswamy himself has chosen, saying Trump's opponent should focus on persuading voters that their candidate is the best choice. Just go vote for Biden against the insurrectionists. And trusted voters will choose the candidate who best meets the moment. Saying if you allow this decision to stand, Supreme Court, the Colorado Supreme Court decision will lead to opening the door to similar challenges, and more plaintiffs of all political persuasions will gladly accept the invitation. And in the absence of clear guardrails, Section 3 will mean whatever a given state official decides that it means, just like they did. And you can hold a fake hearing over 5 days where a judge just hears evidence from Liz Cheney's totally rigged January 6th committee report, just accepts it as evidence, decides this was due process. And then Maine doesn't even care. Like Maine doesn't even go through that whole, that's a lot of work to have a hearing. 5 days. Shenna Bellows like, I don't even want to, they already did it in Colorado. That's due process enough for me and my voters. So Trump also goes. It's going to be dominoes like crazy. Now, Section 3 will become a patchwork law whose words will hold different meanings to whatever state decision maker decides is appropriate. Saying the decision below from Colorado makes perverse incentives for state decision makers, whether they're state Supreme Court judges like in Colorado or whether secretaries like in Maine, Secretary Bellows. Those two states have already removed Trump, and their actions, if they're allowed to stand, more will follow. It will be dominoes. The Supreme Court, if you give state officials this new power, they're going to use it. When they do, it's going to be wielded as co-partisan hacks. We've already seen this. The Maine Secretary of State has already gone on CNN and MSNBC, Shenna, and has given a national platform to explain her decision. She's increasing her name recognition and saying she thinks it's right. Although this time we have witnessed a state Supreme Court composed of Democrat appointees. They vote to disqualify a Republican. That happened in Colorado. Now, they say the hypothetical is not particularly far-fetched. Imagine a 2028 election in which state officials proudly tout their willingness to disqualify disfavored candidates, right? Like Tishy did. Letitia literally ran saying, I'm going to prosecute Trump. So now all secretaries of state can say, I'm going to run to disqualify the MAGA party, whatever, whoever comes next. They just make it up. Now, it's easy to foresee a world in which candidates use this to curry favor with their other partisans and promote themselves. But it's going to hamstring election officials and it's going to undermine the entire system. If you allow states to have the final say, says Vivek, on presidential qualifications, a motivated group of partisans, even more than we already have here, are going to file removal challenges. And it's going to have an entirely different meaning in different locations. Saying all these factors show the states are not appropriately equipped to handle this claim and this type of issue. So beyond the perverse effect that this would have on state office holders, because they would all be incentivized to go remove people, this is going to turn into headaches for the court. If Trump's political opponents get him thrown off the ballot, it's going to equate to a clarion call for partisans nationwide. The number of Section 3 challenges are going to proliferate. There's not going to be any limiting principle. Now, while some components of Section 3 lend themselves to easy judicial interpretation, that is not true of every element. To find Trump ineligible under Section 3, Colorado had to determine that one, Trump engaged in insurrection, first of all, and then given those constraints, Ramaswamy is not going to try to define that phrase. He asserts that neither the lower court here nor the secretaries are properly equipped to analyze that phrase either. standard. And so this court demands that if we don't have fair standards, if we don't know how to measure this stuff, then you don't measure it, right? They don't have permission to do it, so is not in their jurisdiction, in other words. Here, Article 1 expressly vests Congress with the power to suppress insurrections, and the power to remove disability goes to Congress if someone is impeached. So Congress is the actor. It's not clear what standards a court or any court could use to decide those other questions. They say here, if a former president can be disqualified upon Section 3 on actions taken by his political supporters, could an incumbent president also be disqualified from running for re-election based on the unintended, perhaps violent consequences of an intentional presidential policy? How will the court make those determinations? Ramaswamy understands that each of these examples will strike the court as tenuous or even absurd. That's because they are, but that underscores there are no judicially manageable standards here, which is the point of this case. We have a little history lesson here. They say in 1980, President Carter signed a finding of authority authorizing the covert provision of Soviet occupation sending arms to the Afghan Mujahideen. The Reagan administration continued the Carter program and eventually increased the money to $100 million. Now, after the Soviet military withdrew, guess who came into control? The Taliban. Oh, no kidding. This violent group gained control over the entire country, and the terrorists planned the 9/11 attacks. Then the Taliban refused to hand over Osama, the mastermind. Now, imagine the political opponents of President Carter or Reagan. Imagine they had filed challenges to their eligibility, saying that each man had deliberately pursued a policy of delivering dangerous weapons to another group of dangerous men, and once they gained the capability, they attacked the United States, which in fact they did. Remember 9/11 that Joe Biden and the Democrats forgot about? January 6th, they forgot about everything, man. In short, the complaint would allege that these administrations had given aid or comfort to the enemies of America. Now, although the long-term effects of this bipartisan policy may not have been clear at the time, the risks are obvious in hindsight. So Reagan gets indicted and removed. Not even indicted, just removed. Some secretary, you're gone. And everybody who was involved. You were involved with that, weren't you? You were part of the Reagan administration. Did you help with that? Oh, you worked in his cabinet, didn't you? Okay, one of those situations. Everybody was involved. And you get another Liz Cheney back then, who's just wrecking the country back then in the 80s. What about President Clinton? On August 11th, 1999, Clinton granted clemency to 16 incarcerated members of the Puerto Rican terrorist group called the Armed Forces of the National Liberation. Now, according to the FBI, this group was responsible for 146 bombings and a reign of terror that resulted in 9 deaths and hundreds of injured victims. Bombs that were linked to the FALN were detonated at FBI headquarters and the federal courthouse in Brooklyn. Wow. Thereby directly targeting the federal government. Now, Clinton claims that the sentences were disproportionate to the crimes, was quickly belied by the Sentencing Commission, which affirmed a pre-existing assessment of all sentences. Yeah, they were involved with terrorist activity. Now, if President Clinton had been eligible to run again, could his historical political opponents have tried to remove him? Yeah, it would not have been difficult to marshal evidence saying, hey, these terrorists were dangerous men. The entire federal government opposed Clinton's actions. Why did he do it? The FBI had uncovered evidence that 2 of these, those on the clemency list, intended an imminent attack at a U.S. military installation right before their arrests. Both chambers of Congress passed measures condemning the commutations by bill, and with this mountain of evidence on their side, Clinton's opponents could have easily said, he let these dangerous men go from prison, and it constituted giving aid or comfort to the enemies of the United States. Love that. Yeah. Go after Clinton. Go after everyone. Go after Obama. Vivek says from late 2009 to early 2011, Obama operated ATF. Oh, you remember the Fast and Furious program that was monitoring the weapons that were going to Mexico drug cartels. Essentially, the ATF, long story short, allowed cartel-connected buyers to purchase firearms in the hope the ATF could then trace those weapons back to the cartel leaders and then make arrests. Now, one of those, quote, straw buyers that was monitored but not arrested bought more than 600 of the 2,000 weapons linked to the ring. Now, once again, a federal policy of giving guns to cartels perhaps is giving aid and comfort to the enemy. Why? Because guns that were linked to Fast and Furious straw buyers, they were found at the scene where a Border Patrol agent was killed. So Obama's ATF sold guns to cartel leaders who came back and killed a Border Patrol agent. Interesting. Now, in that instance, the unintended but fatal consequences of the operation were revealed before the president who implemented the policy competed as a candidate for re-election. In other words, maybe a bunch of Republicans could have said, oh, you gave aid and comfort to the enemy. You helped insurrect America. You're removed from the ballot under the 14th. Nicely done. If political opponents, like against Obama, had challenged his eligibility based on Section 3, this court would have to weigh in. Again, the situation would have demanded demanded a judicial determination of whether presidential policy that resulted in the death of a federal agent rose to the level of giving aid or comfort to the enemies. Don't know. Now, to make even the question even less hypothetical and even more contemporarily relevant, let's get to President Biden. Saying President Biden voted for Reagan's request to increase military aid in Pakistan. Oh, that's right. Biden was a senator for a long time who supported a lot of these things that gave aid and comfort to our enemy. He voted to increase military aid to Pakistan, and thereby he facilitated the Mujahideen, the resistance against the Soviets involved. And he also served as Obama's VP when Operation Fast and Furious was conducted, resulting in a dead Border Patrol agent because they sold guns. So if this court blesses the Colorado Supreme Court and their overly broad reading of the 14th, it could throw both major party nominee processes into disarray. And to be certain, multiple eligibility challenges can and will be lodged against the leading candidates with a rapidly shrinking window within which the court can fully adjudicate those challenges. So Joe Biden voted to fund essentially the Taliban that then led to attacks on America. And he also supported via his vice presidency dead Border Patrol agents. So make no mistake, if the lower court's decision is allowed to stand, says Vivek, these are precisely the kinds of Section 3 challenges that partisan litigants will file. Sounds like a good one. I like that one. Now, Section 3 saying here, there'll be far more chaff than wheat. Courts are not well equipped to evaluate the wisdom of some given presidential policy, particularly when the adverse effects of such policies do not become apparent until after their implementation. Without judicial standards, the best part of this process is that this court should defer to the political process and to the collective wisdom of the American people as expressed through elections. But they do not want that to happen because we don't believe them. They've created a fake narrative and they say, oh, Trump is the worst. He's an insurrectionist. And because the country doesn't buy it, they have to take the decision away. So Vivek continues saying, the president is not an officer of the United States. Now, even beyond the many prudential concerns as were already outlined above, there are strong reasons in the text why Section 3 doesn't apply to the president. First of all, neither the drafters of the 14th Amendment nor this court have addressed whether the disqualification provision applies. Now, people who love Colorado and the Democrats on that court, they must first contend with the fact that some of the earliest drafts of what became of Section 3 did expressly mention the president. So 14th Amendment version 1 on your Word file, it included the president, but the final version does not. So they talked about it and they deleted it. Representative Samuel McKee of Kentucky, he filed a proposed amendment when they were in session, February 19th, 1866, that would have prohibited any person from qualifying for holding the office of President of the United States, that's the language, draft 1, if they had been or shall hereinafter be engaged in any armed conspiracy or rebellion against the government of the United States. Now, this original draft is a model of textual clarity, inarguably prohibiting any person who had engaged in rebellion or did so in the future, whether they were an office holder or not, from qualifying for president. Now, the scope of the provision, however, narrowed considerably through subsequent revisions because maybe they thought that's not that good of an idea. Because what happens if a government just comes in and says, oh, that's a rebellion, that's an insurrection, and so the president is now disqualified because Liz Cheney, some hack, decided he committed insurrection? No, the people get to decide. And by the way, if the people decide, it's not an insurrection, right? They've decided that it is the person that we want. We say he is not disqualified. So the scope of the provision went through other revisions. They thought that's not that wise. By the time the final version reached the Senate floor, the only debate over the application of the amendment to the presidency focused on the offices that Section 3 prohibits a disqualified individual from holding. So any office, civil or military, under the United States, rather than which types of office holders are disqualified from holding those offices. One senator questioned why ex-Confederates should not be excluded from the privilege of holding the two highest offices in the gift of the nation, right? They're talking about this. This is all after the Civil War, remember? So why should Jefferson Davis be elected? Like if the country wants him to be elected to the presidency, why? A colleague then called the senator's attention to the words, or hold any office, civil or military, under the United States, implying that those words encompass the president and the vice president. Now, even if one finds the opinion of a single senator on this point convincing, so this senator did think it does apply, which is a dubious prospect given that we are governed by laws and not the intentions of legislatures. So that's like kind of bad law there. Saying here, no senator raised any questions about the meaning of the phrase, an officer of the United States, within the context of Section 3. Now, although 21st century commentators believe that the drafters of the 14th should have been concerned about the prospect of re-electing an insurrectionist president, that does not mean that those working in 1866 devoted any thought to that possibility. Drafters of constitutional amendments are not omniscient. Sometimes the drafters' silence is best explained by the simple fact that no one, not even the amendment's most ardent supporters, suggested the document might have such effect. Now, in this case, one can find scattered examples of non-ratifiers who believe the text applied to the president, but that evidence is no more dispositive than the opinions of the Substack people. So in other words, people were debating it, and they're relying on the stuff that people are debating to say that this guy said this and this guy said this, but he's saying it didn't make the text of the law. Now, what this case requires are examples of framers and ratifiers' testimony sufficient to support the claim of today's consensus understanding, but that body of evidence does not exist. And he goes through, he says there are other cited examples of this. John Tyler, president from 1841 to 1845, and John Breckinridge, vice president, 1857 to 1861, both of whom later joined the Confederacy, shed no additional light on whether Section 3 applies to former presidents. Along with their stints in the executive branch, both Tyler and Breckinridge had served several terms in the Senate and the House of Representatives, and as such, they had each taken the Article 6 oath to support the Constitution several times, meaning that Section 3 did not need to be stretched to encompass them. Now, as has been seen elsewhere, the language of Section 3 overlaps with the language of Article 6 oath or affirmation. It does not, however, overlap with the presidential oath in Article 2, Section 1. Therefore, Section 3 unambiguously disqualified Tyler and Breckinridge from further government service without reference to their tenures as vice president or VP president. So in short, Vivek says proponents of disqualification look to scant evidence. They just pick and choose from the ratification debates, and they see a blank slate on which they can just insert their evidence. But the more reasonable conclusion, says Vivek, is that the drafters of Section 3 did not believe it was possible for a president to engage in insurrection or rebellion against the government that he led. It says might be less satisfying to modern ears, but it is more consonant with reality. Wow. And now, as Professor Lash's historical research has shown, the concept of the United States electing an insurrectionist president in the immediate aftermath of the Civil War was no more than a punchline to a joke, and thus not realistic enough to even require a constitutional amendment, saying that the word officer also, by the plain text of it, doesn't include the presidency. Now, the word officer is used 12 times throughout the Constitution. You see it here, listed boom, boom, all throughout. Now, early 19th century jurists were not confused by the mountain of the one-sided evidence. Justice Story brought this up. Now, at least two of the founding era sources also conflict with this evidence. Both provide a thin reed on which to conclude that officer encompasses the nation's chief executive. Alexander Hamilton said in Federalist that the president would be an officer elected by the people for 4 years, in a passage that contrasted the limited powers of the presidency about being a perpetual king. The likeliest explanation is he's saying Hamilton was speaking colloquially. Okay, so he was saying officer was just like, he's like an officer. He's a position. It's a person. It's a role. It's an officer, but it's not an officer, capital O. Saying here he was just talking colloquially. Elsewhere in Federalist Papers, he appeared to distinguish between the president and other officers. In other words, if you just look at the plain text and the treatises that come before the 14th Amendment, proponents of disqualification are relying on extra textual evidence, stuff outside the text, to support their theory, and that is not appropriate. Saying just go through traditional canons of construction. Just read the text. You'll see it's pretty clear. Break the text down. It lists 4 relevant categories of persons: members of Congress, officers of the United States, members of state legislature, executive, and judicial. The only one of these categories that could possibly encompass the presidency is the officer of the United States, is officers. But to accept that argument, a reader would have to assume the drafters crafted a specific category for Congress while declining to do so for, the presidency, the most powerful position in the constitutional system. Wrong. The drafters of the 14th were plainly aware of a possibility that a former president could support a movement that took up arms against the United States. Indeed, John Tyler had done so a mere 5 years earlier. It would have been a simple matter to expressly list the president for the sake of clarity and just to be certain, but the men who actually drafted the amendment didn't. And because the omission of the president from Section 3 is so glaring, that which is omitted must be intended to have the opposite and contrary treatment. Here, that means the president is treated differently than members of Congress because it's not listed there. Saying other categories are explained as well, but Congress does not hide elephants in mouse holes. This court's precedent teaches that Congress does not alter the fundamental details in vague or ancillary provisions. One might say Congress does not hide elephants in mouse holes. In short, you'd have to extrapolate a lot from this thing. It beggars belief that the drafters of of the 14th Amendment, they tried to just insert the presidency into the elephant, which is the elephant, into this little officer phrase. Mr. Ramaswamy's interpretation is much more plausible, and other structural conditions in the Constitution support this interpretation. The full extent of the power of the presidency is set out in Article 2. The executive power shall be vested in a president. Constitution could not be clearer. One individual, not multiple, is vested with all the executive power. Clear, all of it. Full stop. And they hate this, man. I know it's uncomfortable for them that Trump is going to have all this power again, but it's true. Got to deal with it. Start preparing on the left. Prepare yourselves. And although the president has always enjoyed the power to appoint officers to assist him, he doesn't need to do so. A president could lawfully exercise all executive power by himself without making a single appointment. And since the Constitution was ratified, there have been those who claim that a vigorous executive is inconsistent with the genius of Republican government. But hobbling the executive has been discussed. Madison explained this, saying in Federalist 51, one of the best, that ambition must be made to counteract ambition. One of the most, I would say, prevalent phrases from the Federalist Papers. In no branch is the interest of man more intimately connected with the constitutional rights than in the case of the executive. And so a lot of details there. But Vivek wraps up. He says the president is not a monarch, but he's not a mere bureaucrat either. Now, although the president may not exercise legislative or judicial authority, he may wield the entirety of the power vested in him within the executive's constitutional sphere. And from 1789 to the present day, today, an energetic executive has been vital to the country. Now, for all these reasons, both those expressed in the text and those implied in the structure of the Constitution, the president is not an officer of the United States. And so for an individual like Trump, who's only taken the presidential oath and no other, this determination ends the inquiry, and we do not need any further analysis. And so Vivek submits this, saying, Supreme Court, for the foregoing reasons, the court should reverse the decision of Colorado and keep Trump on the ballot. Signed here by the team representing Vivek in the Amicus Brief, friend of the court brief, landing at the Supreme Court of the United States from Vivek Ramaswamy, the only other Republican who has any concern in the primary about what Democrats and the left are doing to Trump. Now, the question is, what is the Supreme Court going to do? Are they going to allow Trump to remain on the ballots? Nancy Pelosi seems like her position is that it's going to be impossible for Trump to win. Why would that be? Here's Nancy.
Individual basis, every single piece that you laid out there pulls quite well. You lay out what the former president has said he wants to do in terms of repealing Obamacare, in terms of being proud of Roe versus Wade being struck down, in terms of more tax cuts along the lines of what you saw in 2017. That also polls much better for Democrats than it would for him. And yet, this is a neck-and-neck race, and no one feels very comfortable on the Democratic side of things that Donald Trump isn't going to be the next president.
Well, I don't think that nobody feels. I think many of us know that it is impossible for him to be the president again with what he is proposing. Well, because when you're talking about what he's talking about now is more tax cuts for corporate America, taking them down so low to the detriment of our budget and meeting the needs of people. But people have to know. I have said over and over again, President Lincoln said public sentiment is everything.
Right.
With it, you can accomplish almost anything. Without it,
public sentiment, like, being allowed to vote for someone, like we could go express that sentiment through the polls. Public sentiment is showing that people do not like Joe Biden.
Practically nothing. But public sentiment has to be informed. People have to know. So we can talk more about what...
we're too stupid. That's right. We have to get more education from Nancy.
He has done, what it means at the kitchen table for people to have lower costs for prescription drugs, lower costs for health care, because it's not just about their good health, it's about their financial health and security as well. Instead of just talking about why aren't they doing more, we are and we will. And again, the outside, our inside maneuvering to get the job done, the president's vision for our country, his knowledge of the issues, his strategic thinking as a legislator are so important, but so is his emotional connection, the empathy he has for working families in our country. He springs from that background, he understands it, and he cares about it. That's what that you will see. Again, the president and millions of people mobilizing outside to get the message out, neighbor to neighbor, friend to friend,
right,
person to person.
Do you wish he was, you make the point about kind of...
Okay, I don't really know what she was saying there. I was kind of more distracted. Does she have like two sets of eyebrows here? Like this is the actual eyebrows, right? This is the actual eyebrow. Is that also an eyebrow here? Like I know that you have like your eyes can be indented there because like your eyes will go back and be indented and it might be a shadow, but I don't know that's just a shadow, is it? She has two eyebrows. Am I wrong about that? Am I totally like missing something? I have no idea what she said. Honestly, I have no idea what she said, which is fine because because she's mostly drunk most of the time anyways. Other than it's impossible for Trump to be the president. I think they're going to censor us harder, or that's the solution. All right, so impossible for Trump to be president again. I don't know if they've got some plans. I don't know, sat down with John Roberts at the Supreme Court or what's going on, but hopefully somebody can figure out what's going on with their eyeballs. Here is Alina Abba, who, as you'll notice, doesn't have two sets of eyebrows. Okay, let's listen to her and see what she says. Now, she's talking about the New York case. In New York, Tish James is aggressively prosecuting Trump, trying to extract over $300 million from his company. And we know that Tishy met with the White House. And so just like the Democrats are trying to throw Trump off the ballot in Colorado with the judges, in Maine, Shenna Bellows, another Democrat trying to throw Trump off. We know the White House met with Letitia James. We know the White House met with Fani Willis. We know Joe Biden has made statements to Merrick Garland, like, I'm upset about Trump. And then he went and prosecuted Trump by appointing deranged Jack Smith, illegally, by the way. So here is Miss Abba, who's out explaining what this all means.
We saw that there was a meeting in August, the month or two right before they filed their complaint. And there was another meeting later in the midst of our litigation on the Attorney General's claim. So that is twice confirmed. I believe there are also reports that she had been at Miss Kamala Harris's home.
Oh.
This is not normal. She is a New York Attorney General.
Kamala Harris's home. Isn't that curious? What are they doing in there? And Letitia, she takes her shoes off, okay, even in the middle of courts. And I don't know what that's all about, but, I'm sure that's just not very inviting household to be in.
Voted by the New York constituents, and the only thing they all have in common is the Soros backing. I cannot understand why she would have cause in the middle of a trial to go see the White House and the Biden administration, let alone the top. One of the records said that they met on the front lawn. I can't believe what I'm seeing. I really can't. And I am with you, Sean, reporting with you every day. I am in the weeds, and I still am shocked. They cease to amaze me. This is unbelievable. I thought Georgia was bad, and then today I have to sit in court and get notice that this person has now weaponized her, which we already knew, but now that she's coordinating as well with the Biden administration. What was she there for? Coffee? We don't believe it anymore.
No, not coffee, Alina. She's there palling around with her political pals who want her to take out their opponent. And of course, that's exactly what she's done. So this is Kevin O'Leary, and he showed out on CNN. This is interesting. We're hearing a couple clips here. Yesterday, we had Eli Honig, who was on CNN, saying, yeah, Tish is clearly, clearly partisan, clearly political, was running her entire campaign on Get Trump. So we have another clip here from Kevin O'Leary, who says the same thing, saying this is normal activity in New York. This is what every real estate individual looking for a loan does.
You've been doing real estate for decades. Does this case strike you as odd?
Well, let's leave out Trump for a minute, and let's leave out politics and just talk about what happens in real estate development anywhere. So if you're a developer and you've got a building on a block anywhere in America and it's worth, let's say, $500 million, and you want to build a building right beside it, you go to the bank and say, this building is worth $500 million. I'd like to borrow a construction finance loan against this asset, and I want you to tell me it's worth $500 million too. And the bank negotiates with you and says, well, no, we think it's worth $400 million. And you fight it out. You're always trying to show your assets in the brightest light with the sunshine you can possibly determine for them. You want them to be worth the very most because you're only going to get a 40 or 50% loan to value, as it's called. Then you borrow that money. In the case of a $500 million asset, maybe you get $250 million, and you build a new building with a construction finance loan.
Makes sense.
And so that's what this case is all about. And by the way, forget about Trump. Every single real estate developer everywhere on earth does this. They always talk about their asset being worth a lot, and the bank says no. And that's just the way it is. So in this case, when I'm trying to figure out, and I'm not pro or con, or I don't care about the politics, who lost money?
No one.
Nobody. The bank got paid back the construction finance loan, and a new building was built. And if you're going to sue this case and win, you got to sue every real estate developer everywhere. This is all they do. This is what they do all day long, every day.
No, they're not Trump,
so
though.
I don't think this thing will ever survive appeal, regardless of what the fine is. This doesn't even make sense. Now, look, I know Trump's got a lot of problems in other indictments and everything else. But
those are also fake, Kev.
if you're a real estate developer, you're watching this, you're saying, what is this? This is ridiculous.
You don't even have to be a real estate developer, okay? We're also saying the same thing. What the heck is this, right? So Kevin O'Leary, now the fact that they brought him on CNN to make that point is kind of nice. Like, wow, that's interesting. Yeah, CNN. And what you've been cheerleading for the last several years is now being called out what it is, a partisan attack. That's madness. Now, here's Vivek, who submitted an awesome amicus brief. And so we're going to give him the final word here on the segment, explaining what is coming next. And we know, my friends, this is the last show of the week before we get the Iowa caucuses out there. And so Trump is looking far and away like he is going to be winning there. And we'll see how Vivek does. But right, if Vivek has a good showing in Iowa, if Vivek has a good showing in New Hampshire, that might be a good thing for any people who are interested in a prospect of Vivek as the vice presidency. If he could do better than Haley or do better than Ron, that would be a good thing. Might bump him up in the race there. But this is what he said. He says, here's the plot. You narrow this to a two-horse race between Trump and a puppet that they control. Number two, eliminate Trump. SCOTUS can do it. We'll see what happens. Number of different ways for this to go. You could see SCOTUS could defer to the states, say must states' rights, send it back down. Trump is no longer eligible to be on the ballots. RNC boots him out. Supreme Court rejects presidential immunity. Currently, that is at the Court of Appeals in D.C. You work that up to the Supreme Court. Supreme Court rejects that. Says, nope, we're going to let Chutkan stand. Trial comes back on. March 4th trial date. Chutkan puts it right back on place. Trump gets convicted. RNC turns around and says, we can't have a convicted felon. He's been convicted of insurrection. Whatever that is, we get a whole new slew of legal challenges because of the conviction. He's a convicted felon now. So that's going to open up the floodgates. Oh, he was convicted of a January 6th crime. Oh, okay. So then they're going to try to remove him. And so maybe the party says, we've had enough. We don't need to deal with it anymore. So all they got to do is just keep this now, maybe Nikki and Ron, keep them around. And then all they have to do is trot their puppet into the White House. So Vivek says, next up, Ron DeSantis joins Nikki Haley ticket as the vice president. Ron may not know it yet, but he's not even going to have any say in the matter. Here is Vivek.
The system wants to narrow this down to a two-horse race between Donald Trump and a puppet who they can control. And it has become increasingly clear that puppet is not a Democrat. It's not even Gavin Newsom. It's Nikki Haley. It's in our own party. Well, today, one more step in that plot unfolds. Chris Christie drops out. Next up, I'm going to make a prediction. You're actually going to see Ron DeSantis join Nikki Haley's ticket. He's going to be her VP. The whole game, it's hiding in plain sight. Whatever it takes. And this system will stop at nothing. And I mean nothing. To eliminate Donald Trump from contention. It's disgusting. But the same people who have said they're not going to actually take a principled stand against Trump's removal from the ballot. Haley and DeSantis are both in that category. Do the math, people. That's next up. Ron DeSantis is after Iowa. Everybody, including Chris Christie, apparently got a phone call from Ron DeSantis. Panicked was the word that Chris Christie used. This is the way the plot's going. Ron may not know this. Ron DeSantis may not know this. But that's what his donors are going to make him do. That's what's coming next. Ron DeSantis will become Nikki's VP. Whether or not Ron knows it, it's not really his choice. He's not the one in charge of that decision. And then the plot continues. We have to open our eyes and not fall into their trap. Our America First agenda cannot end. Our movement cannot end with Donald Trump when they take him out from contention. And if you think this system is going to even let this man get anywhere near the White House, we need to open our eyes. We need to do the right thing for our country. They are selling us the rope today that they're going to use to hang us tomorrow. Do not fall into the trap, people. And that's why I'm here.
All right. Seems plausible to me, my friends. Now, as we've talked about here, it has been wild to watch them shatter everything, break glass in case of emergency. The whole justice system, the whole structure of the country is rapidly changing. And we now have a position where in 2 states, they've already decided that you don't even get to vote for the person who's in charge, number one in that political party. It's not even a choice anymore. So the country is shifting rapidly, very rapidly. So the idea that we wake up and there is something else, Supreme Court says something or something else goes askew, is not out of the realm of possibility. I mean, I know for a long time, there were many people who thought that they were not even going to indict Trump. And the idea that a president would be indicted seemed like insanity. Well, it's now happened 4 times now, and the goalposts are shifting. So very interesting statement. I'm sure he's hearing a bunch of stuff that he's not telling us about, and he can see behind the curtain, so to speak. So Vivek is out there issuing a warning, and what I think he's doing is good work. Appreciate his voice. I know people have some questions. Where did this guy come from? Why is he so smart? Why is he talking the way he's talking? But the things that he's doing, right? The words mean things. Words have impact and meaning, and he is filing very nice, very substantive briefs to the Supreme Court. And I think he's speaking a lot of truth about what the other side is trying to do. Whether that ultimately comes to fruition, I don't know. I think that a removal of Trump would be, a real fracture that this country would have a lot of difficulty coming back from. But they are willing to do literally anything. I've never seen all all of these different sort of shatterings of precedent all coincide around one incident, one individual, one election. It's wild. So I'm concerned that they'll do just about anything, just like Vivek says, and we'll be here to continue to cover it, my friends. And so thank you for joining us as we do. We're going to be covering all the Trump trials, all the Trump cases moving forward. There's going to be a lot to attend to in this new year. And so thanks for joining us. I appreciate you subscribing. Thanks for leaving a like. Thanks for also checking out robertgovea.com. The links are down in the description below. So you can go to our website if you want to read any of the PDFs. They're all there. If you want to sign up for our newsletter, you can do that there. You can also access the mind maps if you want to navigate around this thing. Check it out, robertgovea.com. We'll be looking forward to seeing you right back here on the next one.